Hello and welcome. You are about to meet Bruce and Donna Wilcox, a loving yet mildly dysfunctional married couple with issues. Most of their issues are of absolutely no interest to us. However, they do have some legal issues that we may share. For example, what happens to my property when I die? Do I need a will? Is that different from a living will? What if I get sick and can't take care of myself? Do I need a health care power of attorney? What about a general durable power of attorney? And so, Bruce and Donna Wilcox are on a mission to get answers to these questions. A mission to see their lawyer.
Well, good morning, Bruce and Donna Wilcox. Thank you for coming in today. My name's Anne Bamberger. I'm an attorney with Pisgah Legal Services.
Can you hear her?
I can hear her. I don't know why I need to. I don't even know why we're here.
Well, let's talk about that. It's my understanding that you've come in to prepare some documents.
Well, it was all her idea anyway why we're here.
Well, I know that we need to have a will, like I've told you. We need to have a will or the state or get it. Well, you don't listen to me. Maybe you'll listen to this nice young lawyer.
Okay.
All right, well, let's talk about a will and what that is. A will is a legal document that allows you to control how and to whom certain assets owned by you will pass at your death. Even if you have very little to leave, it's important to have a will. You can lessen the burden on your family and prevent confusion and disagreement among your heirs. And then if nothing else, you can name the executor, which is going to be the person who oversees distributing your property after your death. If you don't have a will in place, it doesn't all go to the state.
Oh.
But what happens is the North Carolina general statutes, the rules of North Carolina will apply, and that's called intestate succession. And under that, your property will be distributed, in the order set out by the statute. An administrator appointed by the probate court will be the one acting as the executor and handling your affairs. Your property may go to certain relatives that you don't even like anymore and don't want to have anything to do with. And if you have minor children or custody of grandchildren or a minor child, someone that you may not approve of could be named their guardian. So it's important to plan ahead and draft your will so that you can be sure that your property is going to be distributed the way that you want it to. You've got to make a will while you're competent to do so. And what that means is that you need to have testamentary capacity. You need to be able to know what you're signing, that it's a legal document, what it means, and what you're doing. It's going to have to be signed in front of a notary and 2 witnesses who are not related to you. You have to be free from any undue influence from any other people. So it's important to think about having a will in place, to know what you have and where you want it to go, and make a plan so that your wishes will be followed.
I agree, and I think she ought to do it. What do you think? Can you hear me?
I can hear, and we'll talk about it. We'll go home and talk about it.
Well, no, we're supposed to take care of this today.
Well,
You don't know, you might get hit on the way home.
well, that's true. You never know.
And then the kids will fight, and look what you'd leave me with.
Well, they'll fight just like they fought over when my sister was sick, when Nelda was sick. They fought over whether to pull the plug or not.
Well, what does that have to do with the will?
Well, I don't. Is this a living will? Isn't that what that's about?
There is a document called a living will, but it's different from a will. It's a separate document. As we discussed, the will controls what's going to happen to your property after you die. A living will is a document that you sign now while you're well and competent. That's basically instructions to your doctor or the medical providers about what your wishes are when you are at an end-of-life stage. And what that means is that you're in a condition where you have an incurable or irreversible condition that will result in your death within a relatively short period of time, or that you are unconscious and to a high degree of medical certainty will never regain consciousness, or that you suffer from an advanced stage of dementia, and for a high degree of medical certainty that is irreversible, and you're now in an end-of-life situation. If you're in one of those situations, and 2 doctors confirm that you are in that state, then it will apply, your living will apply, and the instructions that you leave as to whether or not you want what we call extraordinary measures to prolong your life to be withheld or enforced is up to you. And you write your instructions in that document. So you can say that you want to have artificial hydration or nutrition, like a feeding tube, or that you don't want those things to be in place. And you are also, if you have a doctor that you have a really close relationship with, your primary care physician that you see all the time, you can designate that doctor to be the one to make the decision that you're in that condition, end-of-life condition, with the incurable or irreversible situation where you are that's likely to result in your death. If you don't name a doctor, then it would just be whoever the attending physician is. And again, it has to be that doctor plus another doctor that confirm in your medical record that you are in that situation before the living will would kick in. And it is your instructions as to what you want to have happen when you're in an end-of-life situation.
Do you understand now the difference?
I guess I do, but so the doctor decides whether you're going to be on life support or not.
Well, no, you're going to get to make that decision. You, in this document, you're going to state whether you want to have life support or you don't want to have life support. The only thing the doctor is going to decide is whether or not you're in an end-of-life stage condition. Once they certify in your record that you're in one of those conditions, then your instructions that you've made now ahead of time will go into play. And they will follow your instructions as to whether or not you want life-prolonging measures or not. And that way, the burden is taken off of your family. They don't have to struggle or fight amongst each other as to whether or not you should be on life-prolonging measures, whether or not they, people say pull the plug. This is your set of instructions to your doctor that you leave about what you want. And so it's a good idea to think about this ahead of time and go ahead and do one of these documents, execute one of these documents, so that the burden is taken off your family in that situation. If you don't have one of these documents, then what will happen is if a doctor certifies that you're in one of these end-of-life situations, they will look to either your healthcare power of attorney if you have one, or your guardian if you've had a situation where the court has had to appoint a guardian for you, or the majority of your next of kin. And again, that can cause a lot of strife in what's already a very difficult, stressful situation for your family if family members don't agree on what should happen. So it's a good idea to plan ahead, get this document in place, and take some of that burden off of your family.
You said something about another piece of paper or form or something about a healthcare?
A healthcare agent.
Okay.
A healthcare power of attorney.
So that's yet another document we need to know
there
about.
Are lots
well,
of
we
documents
need to go to law school almost to know about all this, don't we?
Well, it is a lot to take in, and that's why I'm glad you came in today so that we could talk in person and go over what these documents are. The healthcare power of attorney is a document that you sign. You need to sign it while you're healthy and competent, and you can make decisions, know what you're doing. It's a document that you sign where you appoint an agent who will be able to make healthcare decisions for you when you're in a situation where you are unable to make or communicate those decisions on your own. And this is different from the living will, because the living will is really, it's just instruction from you to your doctor or other healthcare professionals as to what you want to have happen when you're at an end-of-life stage. The healthcare power of attorney is a situation that covers when you are incapacitated, where you're unable to make or communicate healthcare decisions. For
That's
example,
like Nelda, when Nelda couldn't tell us what she wanted.
right, like if you're in a car accident and you are comatose for a while, and a decision may need to be made about whether or not you have a certain kind of surgery or you are on certain medications, and you may be in a situation where you can't make or communicate those decisions. But if you have drafted a healthcare power of attorney, you appoint another person to act as your agent. And that person will be able to make decisions for you to the full extent that you would be able to if you were in a situation where you could communicate those decisions. So it's a document that you set out, you appoint someone to act as your agent, and it's generally drafted to be as broad as possible to allow that agent to make decisions to the full extent you would be able to if you were able to make or communicate those decisions. But you could also, and we will talk about this, draft it to be narrower and only authorize them to make certain kinds of decisions for you. It's important to think about naming someone, and communicating with them ahead of time about what your decisions, your wishes are in terms of healthcare treatment and mental health care treatment. You also need to name not only an agent but a successor agent in case you happen to be in a situation where both you and the person you named as your agent are in the same car in the same accident. You could both be incapacitated at the same time, so you need to make sure you name an agent and then a successor agent, someone that could step in if they're unavailable.
Does it have to be Bruce who makes those decisions? I've got another sister named Janice, and she works in the world of medicine, and she might know better than he would know.
Right, yeah, it doesn't have to be your spouse. It just needs to be an adult, someone who's over 18 years of age and who is competent.
That lets you out.
It also cannot be someone who is currently providing medical care to you or working for someone who provides medical care to you.
Okay.
It can't be someone that might have a claim against you, might have an outstanding lawsuit that would stand to get money from you in some way. And this is to protect you from someone having ulterior motives when they make decisions for you. But it does not have to be your husband. It can be any adult of your choosing. It could be one of your adult children. It could be a friend. It just can't be someone that's currently providing medical treatment to you.
We've been having a lot of talks lately, especially with his memory. He can't remember a thing anymore. There are times he forgets to pay bills, and he won't tell me anything about what's going on. He has to control everything. He has to sign all the checks. He's a penny pincher. I haven't had any new clothes for years. And so what happens if he can't make decisions? And then what happens if I can't make decisions? Who pays our bills? We've got a mortgage on the farm, and we've got to keep up with all these things.
That's a good question. There is another document. We've talked about the healthcare power of attorney. That lets you appoint an agent to make healthcare decisions. But there's another document that we can do today called a durable power of attorney. And this is a document that allows you to appoint another person that is then referred to as your attorney in fact, that's another agent, to act on your behalf to conduct financial transactions or business matters on your behalf. And again, this is a document that you sign now while you're healthy and competent and able to know what you're doing. You name a person that you want to be your agent, and you, in that document, can set out what sorts of financial transactions you want them to be able to handle, what sorts of business matters, and we're going to go through that, that you would want them to be able to act on your behalf. Because, for example, say you were in that car accident and you wound up being in a coma for 6 months. Well, like you said, there are bills that have to be paid, your mortgage has to be paid. If you haven't authorized somebody else to be able to do that on your behalf, when you finally recover, you may not have a home to come back to. So it's important to have these documents in place, and really no matter what age you are, I have these documents in place. You want to have a durable power of attorney, and it's called durable because what that means is you sign it now while you're competent and aware and healthy. But the purpose of it is when you are in a situation where you are no longer competent, when you've become incapacitated, it remains in effect, and it allows that person that you've named to be your agent to conduct financial and business transactions on your behalf. And again, in this sort of document, you want to name someone to be your attorney in fact, your agent, and you want to name a successor agent in case something happens to that person at the same time it happens to you. And again, this can be any adult who is competent.
Well, I just remember when my sister Nelda was so sick, and she's got all of those kids and brothers and sisters, and they all got into a big fight about are they gonna let her have an operation? Should they just let her die? Should they do everything they can to keep her going? And I don't want that. I don't want all of the family fighting over me.
Right, well that's why it's a good thing that you came to see me today, because having these documents in place is a good way to prevent that sort of situation where people are filing lawsuits, getting angry, having a big fight. You know, it's a very stressful situation when a loved one is dying or very sick or, you know, incapacitated and in the hospital. And if you have these documents in place ahead of time, you've already, you know, communicated to the doctor through the living will about what your wishes are in terms of whether or not you have life-prolonging measures, whether or not you pulled the plug or not. You have a healthcare power of attorney where you've named an agent, someone that you've decided is going to be the person to make decisions for you about whether or not you have surgery if you're in an incapacitated situation. And you have a durable power of attorney in place where you've authorized an agent to conduct financial and business transactions for you. But it's very important that when you, in the process of making and executing these documents, that you talk to your family members and let them know ahead of time, yes, I do or don't want to have life-prolonging measures. And in fact, I've drafted a living will. And let them know ahead of time. It's not a good thing for them to be finding out for the first time when you're in the hospital, when they're under all this stress, that, you know, yeah, you do want to have the machines unplugged. You know, they should know about that ahead of time. Also, they should know ahead of time, if you've drafted a healthcare power of attorney document, who you've named as the agent and what sort of wishes that you've conveyed through that document to the agent. It's not a good thing for the first time when you're in the hospital, everybody's upset and worried for one sibling to find out that you've named their other sibling instead of them to be the healthcare agent. So
that's what the fight was. Nobody could agree. Nobody knew what Nelda wanted. It was terrible.
So it's great if, you know, when you're doing these documents to think ahead, but it's very important to communicate to your family and make sure that they understand. Also, you know, when you're thinking about naming an agent in these documents, you need to talk to them ahead of time, make sure they're willing to do it. Because you don't want to name an agent and then have them say, well, I'm not going to do it. I don't. Even if you have named an alternate, you want to talk with these, your friends and family ahead of time, make sure that they're on board with your wishes and your desires. And make sure you communicate that with all the members of your family and close friends. And that's the best way to avoid these situations where you have a huge argument or lawsuits being filed.
Okay, so this is a whole lot of papers you're talking about here.
It is. We've talked about a lot of different documents. It's a lot to take in. So what I'm suggesting is that, you know, I'm going to provide you with some materials and some decisions to make, like we've talked about. Then I'll be drafting the documents. Once I've got them drafted, I'll have you come in. We'll go over them. I'll give you some time to review them. And once you're sure that they communicate what you want to have happen in all of these situations, we'll get you in to sign them in front of one of our notaries and 2 witnesses. And then you'll be prepared. You want to make sure you communicate with your family, give copies to your agents and to your medical doctor, and you'll be set for any situation that might come up.
Okay, well, thank you. We'll be back.
Well, great. I hope that wasn't too painful for you.
It was not as bad as I thought.
You've been very nice and patient. I really do appreciate it, because I understand Bruce can really be cranky. So he must really think you're a nice person. So thank you. We'll look forward to working with you further.
All right, I've got everything all ready for you. Thank you so much for coming in. Now we've got them all signed properly, and you've got all of the documents together. You want to be sure you put those in a safe place. Communicate with your family. Make sure they know where to find these documents when they need them. And hopefully you won't need them anytime soon.
Well,
but I've really enjoyed working with you.
Thank you. I appreciate your help.
And
Thank you. It's nice
in.
to meet you. You've been very nice to us.
Oh, you're welcome. And please, like I said, feel free to call if you have any other questions later.
Thank you.
Okay. Thanks.
Bruce and Donna Wilcox now have answers to their questions. They have wills, living wills, health care powers of attorney, and general durable powers of attorney. 4 documents that we all need. Thanks, Bruce and Donna Wilcox. Mission accomplished.